All right, we touched on criminal procedure in Chapter 3 and in Chapter 4, where we touched on Supreme Court making rulings affecting police's conduct during their investigation. Uh, these are the primary areas we're going to cover involving a Supreme Court cases involving police searches and confessions or interrogations. Matt versus Ohio is the prime Supreme Court case involving search and seizure, and Miranda versus Arizona with regards to interrogation. We know that it is the police, law enforcement's job to prevent or deter crime. And, when crime happens, they have to investigate, they have to find out who did it, and then they have to make an arrest, right? As we simplify it there. And in order for them to do this, they have to talk to people, right? They have to talk to people. And they have to take possession of evidence. It's their job to give the prosecutors enough so that the prosecutor can prove that a crime has been committed beyond a reasonable doubt. But can the police just willy-nilly go in and search homes and cars and boats and sheds and office? And can they force or use forceful tactics to get someone to confess? The police are of the mindset that no matter how hard they press someone, an innocent person would never confess. What do you think about that statement? Think about that. The police are of the mind that an innocent person would never confess regardless of how hard they're pushed. Think about it. If you were shut in a room for 19 hours with no food, no water, and subject to question after question and being berated and calling stupid and don't you lie to me, would you say anything just to make it stop and get the heck on out of there? Some examples of types of interrogation: improper interrogation, the real and perceived intimidation of the suspect by law enforcement, use of force by law enforcement during interrogation or perceived threat of force, compromised reasoning ability of the suspect happens, due to exhaustion, stress, hunger, substance use possibly in some cases, mental limitations, limited education. Young people do not understand their rights, and they're taught to please authority figures, so they're particularly susceptible. Let's use the word vulnerable, as I kind of get talking too fast here. Think about young people. How about this? This is actually, it is okay for police to interrogate young folks, 16, 17, 18-year-olds, without their parents present, let alone an attorney. New York just changed that law when they changed their age of an offender who can be treated as an adult. In 2017, though, is when that changed. It's a fairly recent law where now parents have to be present. Police cannot question children or young people without at least their parents present. Fear on the part of the suspect. That failure to confess will yield a harsher punishment. That's real in interrogation situations. The devious interrogation techniques that are conducted. Police are allowed to lie. They can say untrue statements about having incriminating evidence that puts you at the scene of the crime. They could totally lie about that, and there's nothing wrong with it. So when you consider those real examples that take place, proper or improper, could you see an innocent person actually confessing to something they didn't do? And there is a video that is posted on Moodle. Check it out. It's from the Innocence Project. It's an actual real interrogation of a kid who wanted a lawyer. He kept saying he wanted a lawyer, and the cop said, "You don't need no lawyer," and kept questioning. He kept saying he needed a lawyer, and the cop kept blowing him off. So watch the video. So we're going to jump into a confessions, interrogations. The Fifth Amendment is where we have the right to be free from self-incrimination. We all heard our rights, or those statements that we refer to as our rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you can't afford one, one will be appointed to you at no charge. We are all familiar with those rights. And if we were in a classroom, I'd be looking for hands right now. How many of you believe that you must be advised of your rights when you are arrested? And usually that's a big number of hands that go up. So I'm pretending I see hands. That's untrue. You do not need to be advised of your rights when you are arrested. You might be surprised by that fact, but really that idea came from television and movies. They made that kind of sexy that, you had to have your rights. What it is in the TVs and movies, it's kind of the climax, the signal that, your show is almost over and they got their person. But in reality, the police do not have to advise a suspect or arrestee of their rights when they're arrested, or even handcuffed or placed in a police cart. So when do the police have to advise a suspect of his or her rights? Before we answer that question, we have to answer a couple other questions. Where do these rights come from? The Fifth Amendment says, among other things, no person shall be compelled in any criminal case to be a witness against himself. So the government can't force you to make incriminating statements against yourself in a criminal case. You have that right to remain silent. The Sixth Amendment says, among other things, in a criminal prosecution, you have the right to assistance of counsel in your defense. Nowhere in these two amendments or in the Constitution does it mention paying for your own attorney or getting one for free. It wasn't until 1963, in a case called Gideon versus Wainwright, the Supreme Court ruled that states are required under the Sixth Amendment to provide counsel in criminal cases to represent defendants who are unable to afford to pay for their own attorneys. So that's the legal basis for these rights. However, nowhere in the Constitution or in Gideon versus Wainwright does it say that the police must advise a suspect of his rights. Nowhere does it say that. Which brings us to the case of Ernesto Miranda versus the state of Arizona. And these are the facts. So Miranda, who was 18, was charged with kidnapping and raping an 18-year-old girl. He was detained by police and questioned about it for 2 hours without an attorney. He had a 9th grade education and mental health issues. He confessed and then signed a statement. He was appointed a 73-year-old attorney to represent him. His confession was used against him at his trial. That was really the basis of the case. That was the whole case. And he was found guilty and sentenced to 30 years in prison. And he appealed his conviction. It went all the way up to the Supreme Court. And his argument was that he was not advised of his rights under the Fifth and Sixth Amendments. And the government argued, we don't have to tell you. And it wasn't a criminal proceeding. It was merely an investigation. And in 1966, the Supreme Court threw out Mr. Miranda's conviction and said, no doubt that the Fifth Amendment privilege is available outside the criminal court proceedings as well, and further said that a suspect in custody and being interrogated must be advised of those constitutional rights. And hence, that's why they are called the Miranda warnings. Which brings us back to, so when does the police have to advise one of their rights, one of their rights? Well, according to Miranda, it's when you are in custody or when someone's in custody and being interrogated. So it's just not like you're arrested. You might be in custody because you're arrested, but unless they're going to interrogate you, you're not entitled to have your rights read. You need them both. You need to be in custody and being interrogated. Easy enough, right? Just like that TV show on Netflix, Making of a Murderer. The suspect at the police station, shut in a small room, sitting in a chair in a corner, no food, no water, two big cops sitting inches from him, screaming in his face. That's obvious enough that they're being not only interrogated, but potentially in custody. So let's break these two things down real quick. Custody, formal arrest. You're told you're under arrest. Okay, now you're in custody. The next thing is, we'd like to ask you some questions about this crime. Then you kind of have a signal that you're about to be interrogated. And at that point, you should be read your Miranda rights. But what if you don't know? Formal arrest. We need either a formal arrest or a functional equivalent. And the test is, and we're going to briefly talk about it here, it is when you take criminal procedure, or you have taken criminal procedure, you go into this a little bit more detail. But what would a reasonable person believe under the circumstances? Watch that video. Watch that video of the kid I just told you about who's asking for his lawyer, right? He's not under arrest. He was taken in for questioning, quote unquote, questioning. So you have to ask, am I free to leave? Is this a situation where I'm free to leave? Would a reasonable person believe under the circumstances they were free to leave? And how would you know? Who was asking the questions? How many officers were present? Where did the questioning happen? Did the police knock on your door and you opened up the door, they started asking you questions? Or did they call you up and say, come down to the police station, we'd like to ask you some questions, and you go? Was there any force? Was there any physical restraint? What time of day is it? How long did it last? Is it routine, or was it routine questions? Where do you live? What's your name? Or are they accusatory questions? Somebody told us that you stole blah, blah, blah from the store. Okay? So those are the things have to be considered to determine whether or not you are in custody. And interrogation doesn't include, it has to be, direct questioning. Could be, the point is, are they eliciting incriminating information? That's what you got to be aware of. Not just, hey, so how was the weather in Florida before you came back and we caught you? If they're asking things like your name, whether you have a driver's license, things of that nature. Where'd you get your shoes? It's not going to elicit an incriminating response. What are the questions trying to get at? Okay? So what happens if Miranda isn't followed? You're in custody, someone's in custody, and they weren't read their rights. The statement that's made by the suspect is not allowed as evidence at a criminal trial. Prosecution can't use it. Doesn't mean the case is dismissed and it goes away. The prosecution might have other evidence to prove their case beyond a reasonable doubt. They just can't use that statement. So what happened to Mr. Miranda? Did he get to go home? Nope, there was another trial. And they did not use his statement against him. Instead, the prosecutors ended up finding a witness. They called his ex-girlfriend to the stand, who testified that Mr. Miranda told her that he kidnapped and raped a girl, and he was convicted and sentenced again, just based on ex-girlfriend's statement. Interesting. He served 11 years in prison before he was paroled in 1972. After his release from prison, he got himself a very nice gig of making money selling Miranda rights cards. You can find them on eBay. It's the cards that has all the rights on it. Actually, police officers pull out a card and read a card. They don't whip them off the top of their head. They read right from a card. So he would autograph cards. He'd made money by autographing these Miranda warning cards. And in 1976, at the age of 34, unfortunately, he was stabbed to death in a bar fight. And the man suspected of killing him invoked his Miranda rights and refused to talk to the police. He was released and never charged, and nobody was ever charged Miranda's murder. Interesting story. So the question I pose to you to think about: have criminals been given too many rights by the courts? Should courts be more concerned with the rights of victims or the rights of the offenders? Have the police been handcuffed, quote unquote, handcuffed, and prevented from doing their job in the most efficient manner as a result of this Supreme Court case and the one we're going to talk about again, or next, not again, next, when we talk about search and seizure. We'll revisit the question. So let's talk about search and seizure. It's a very gray area of law. There could probably be an entire course on this amendment alone, like there is for the First Amendment. There are tons of exceptions to this rule. This is going to be kind of a blip of the information, sort of like the overview of what the Fourth Amendment is about. Generally, before law enforcement, any level, law enforcement, local, state, feds, can search and seize private property, they must obtain a search warrant. And what constitutes property? Home, themselves, the person, cars, shed, a warehouse. There's a bunch of places that are considered property. The chest that sits out in the backyard at your house. What's a search warrant? That's an order from a judge authorizing the search and seizure of private property. The warrant has to be specific, and specific in what is going to be searched, what the police are looking for, and what they can ultimately take. So it has to be specific. In order to get a warrant, there must be probable cause. There's that word again, those two words again, that phrase, probable cause, meaning a reasonable basis for believing the search will reveal a specific illegal item. Illegality. Let's use that word. Reasonable basis for believing. Okay, so it's more than a hunch. Got a hunch. There's criminal activity going on in the house. There's drugs in that house, right? More than a hunch. They need a reasonable basis. So what does that mean? Like I said, can't come searching on a hunch. You need a confidential informant. If we're talking about, drugs, they get that information from somebody, someone who's willing to make a statement for the court to get the warrant. The police investigation reveals that property contains an illegal item they're looking for. Maybe they've been watching the place. Could be counterfeit money, guns, drugs, fake credit cards, documents, financial records if they're investigating an embezzlement. But the basis is the required evidence. What's required is required evidence that would convince a reasonable person that the search was more likely justified than not. Okay? Whether or not a reasonable person would agree that the search was more likely justified than not. And this protects, the search and seizure protects not only people, individuals, but businesses too. Both have these protections. The Fourth Amendment protects against searches that violate a person's reasonable expectation of privacy. If an individual expects privacy, it is one that society thinks is legit. All right? So that's what we're looking at. Do we have a reasonable expectation of privacy in our homes? Yes. Do we have a reasonable expectation of privacy in our car? That's a gray area. If you are the driver, the answer is more leaning yes to you than if you're the passenger in somebody's vehicle. The Fourth Amendment itself places limits on the power of the police to make arrests, search people and their property, and seize objects and contraband. These limits are the bedrock of the search and seizure law. And let's talk about some examples. I already gave you the probable cause rule. They need a warrant, and that warrant, in order to get the warrant, they have to show probable cause. There are some exceptions. Oh, I was just going through probable cause, and there has to be this two-part test. Okay? Did the person actually expect some degree of privacy? And is the person's expectation objectively reasonable? Meaning, does society accept that? In my example of the home, does the person actually expect some degree of privacy in the home? The answer is yes. Does society recognize that? Yes. So that's the test for expectation of privacy. If there's no expectation of privacy, then the police are free to search. Okay? A person who uses a public restroom expects not to be spied upon, right? So there's a reasonable expectation of privacy, and most people would consider that expectation to be objectively reasonable. Therefore, the installation of a hidden video camera by the police in a public restroom would be considered a search. That's maybe they think drugs happen in that public restroom and they want to see the drug deals and they want to find out, okay? If, on the other hand, if a police officer stops a car and when talking to the driver happens to notice, oh, look, there's a weapon on the passenger's seat, there's been no search. Why? Because it's right there, right? It's an open, plain view. If it was in the trunk, not so much, right? This is our gray area in the vehicle. But the plain view works elsewhere too. This is my favorite one, living in the North Country, is every fall, maybe you guys notice if you live in the North Country, every fall there's lots of helicopters buzzing around. What are they looking for? Pot plants growing on people's property in in the Adirondacks that we live in. People own big lands, big lot lands, and they plant them amongst their tomato plants. They plant them around on their property, and while the police can't go meandering onto their property and take a look around, in the air, you could see from the sky. They fly fairly low, and they'd be like, oh, look, plain view, pot plants, right? So, plain view, that is a exception to the rule. That's one of the exceptions to the rule. Let's see. I have a couple others here. All right, what if the police came to your house and they suspect there's illegal activity going on, and they knock at the door and they say, hi, we're here, we understand that we got a call, there's illegal activity going on here, can we take a look around? And if you say, sure, no problem, and open the door and let them in, and then they find illegal activity occurring, you can't argue illegal search and seizure without, searching without a warrant, because why? You consented. You agreed to let them search. So plain view, consent. The third exception is if they are making an arrest, they're going to make a search made incident to an arrest, okay? They can search the person and the immediate area around them without a warrant. The reason for this is that there's a valid arrest and they're doing it for their safety, like weapons. They want to remove any weapons from an individual, and if by chance during that search drugs fall out of their pocket, that's not going to be an illegal search and seizure. Let's say they're making an arrest to driving without a driver's license. If you drive your vehicle without a driver's license, that's a crime. That's a misdemeanor level crime, but you would be and could be arrested. And if the officer is doing a pat down search and drugs fall out of the pocket, well, then you can be charged with that too, and it's not an illegal search and seizure. So, to a valid arrest. Number 3. Number 4, emergency protection for society. Under extringent circumstances, they're in hot pursuit of a dangerous individual, and that person goes running into a house. They go running into the house to get this person, but in the interim, there's other activity, illegal activity going on. Or they need to get into a house to stop a threat. Maybe there was a called-in bomb at a house and they needed to go in. It's a little hard to, I gotta get a search warrant and da-da-da-da. They go in. It's for the emergency and protection of society. Emergency situations for number 4. The stop and frisk. This is at Terry versus Ohio. We talked about it. Reasonable suspicion to believe criminal activity is afoot, right? I won't go into it here, but this search was okay. We talked about it in a couple chapters ago, where the police are able to stop and frisk somebody if they believe criminal activity is going to happen, or afoot is the word that's used. So that's number 5. Automobile search. Can be searched without a warrant if there is probable cause to believe it was involved in a crime. Here's this gray area of the car again, right? So if the car was involved, let's say, in a bank robbery, and they stop the vehicle, they can search it without having to get a warrant if the vehicle was believed to be involved in a crime. Why? Because vehicles are mobile and easier for evidence to disappear. And also, it's not as prevalent with this expectation of privacy in your car, when it's on a public street and so forth. So again, cars, gray area. Police can order a driver and a passenger out of a vehicle for officer safety, and they can search those people if it's reasonable and related to their safety. So the car, the automobile search is a little bit stretched. Okay, there was a recent case though that said the Supreme Court ruled, it was a late 2019 case, that the police cannot search digital information on a cell phone without a warrant because there's a reasonable expectation of privacy. So if since it's a good information to know, because they love to look at cell phones. I don't know. I do know why, but if someone has a little bit of information, if you're ever asked by a police officer to give you your password or to open your phone, they need a warrant to do that, okay? And what happens when they violate the search and seizure rule? This is Mapp versus Ohio. All evidence obtained as a result of an unreasonable search, that's what it would be called, an unreasonable search if it violated the Constitution. Any evidence seized as a result of it cannot be used as direct evidence against the defendant in the criminal prosecution. So all the evidence gets tossed out. The fruit of the poisonous tree doctrine is an example of any evidence that falls as a result or comes or gets obtained as a result of that illegal search. So that is what happened. Do you think that's fair? So it's not only the evidence that's the product of an illegal search that's generally admissible in court, but also any additional evidence that's derived from the initial evidence. That's a whole lot of evidence that could get tossed. And then there could be no case. I mean, it could result in a case being ultimately dismissed if there's no evidence in the case. Of course, that would be up to the prosecution to decide. They can move forward if they think they have other reasonable, if they have enough evidence. Otherwise, do you think that's fair? Do you think that's fair? The cops, oops, they just made a mistake. Like I said, the Fourth Amendment is a very gray area in and of itself and can cover a lot. It can cover an entire course in and of itself. Another recent case. A lot of commentary seem to suggest that this search and seizure is getting so gray that it may no longer really be truly in existence. And here was a perfect example that resulted in one of the Supreme Court justices writing a very scathing dissent, meaning they completely disagreed with the ruling. And the gist of it was the Supreme Court found that it was okay that when the police officer secured a warrant to search a particular apartment, went through the steps and got a warrant, and then got to the place to search and searched the wrong apartment. The warrant was for apartment A. The labeling of the apartment was wrong and ended up searching apartment B. There was confusion, and they found illegal I think it was drugs in the it's either drugs or weapons. They found whatever it was illegal, and they found it and arrested the folks in apartment B, and the case turned on search and seizure, and the Supreme Court said, yeah, that was just a mistake on their part. That's not a big deal, and allowed that to on the law enforcement's part, and it was allowed. It was not deemed an unreasonable search and seizure due to police error in going to the apartment. So, very gray area. You'll learn a lot more if you haven't taken criminal procedure yet with regards to criminal procedure. But the two biggest ones affecting law enforcement: interrogations and search and seizure. And that finishes up the lecture material for Chapter 6. Make sure you watch the videos that I cited in the lectures. And we'll move on to courts.